Thank you very much, Mr. Yasa. And please.
Thank you very much, Professor Ninomiya. As he explained, we have been friends for a long, long time. I knew Professor Ninomiya in Japan very well, and as he speaks Japanese so fluently, I didn't even see him as Brazilian. So when I saw him in São Paulo, I was surprised that he could speak Portuguese. Of course he can, but when you deal with him, you just assume that it's Japanese. I didn't realize that he was really a Brazilian. So I was really surprised and pleased to see him speaking Portuguese. Thank you very much for inviting me to give lecture again at the University of São Paulo. It's my great pleasure to come here and to visit the Faculty of Law again. I have been here twice before. It's always a pleasure to visit Brazil and to visit São Paulo, and I'm very pleased to be here today again. So I have an outline of my lecture on the screen. I will talk about the enforcement of international law, and I will follow this outline, and I start with my introductory remarks. And in my lecture today, I will stress that various means of enforcement are available in international law to help secure compliance, and I will examine each of them. But before turning to these various means, I will first address the criticism leveled against international law that it does not qualify as law because it lacks sanctions. So I go to one section as a feature of law. Most lawyers consider that sanctions distinguish law from other social norms, such as morality and religion. Sanctions in this broad sense refer to coercion applied to members of the community to compel their compliance with the law. In municipal law, violations of criminal law are sanctioned by punishment. In civil law, judgments of courts are enforced by writs of execution. It is often argued that international law is not law because it lacks these kinds of sanctions. A well-known scholar who made this argument is John Austin, as you know. As international law lacked sanctions, he considered it to be law improperly so-called. On the other hand, some lawyers have maintained that international law is law by denying that sanctions are the distinguishing feature of law. For example, Georg Jelnek contended that the distinguishing feature of law was not sanctions, but guarantees. However, most lawyers accept that sanctions are the distinguishing feature of law and argue that international law is law because sanctions are available under international law. It is inappropriate to demand that international law must have the same kind of sanctions as in municipal law because that approach assumes the municipal law of modern states to be the only possible form of law. Lawyers have discussed whether international law qualifies as law, despite not having the same kind of sanctions as those available in municipal law. It is well known that Hans Kelsen considered international law as law because war and reprisals were available as sanctions under international law. It is true that before the use of force was outlawed, war and reprisals played a certain role as a means of self-help. A notable feature of international law is that self-help is not excluded. In addition, various other means of enforcement are available in international law to help secure compliance. Thus, international law had sanctions in forms different from those available in municipal law. So I move to the second part, various means of enforcement. In the second part of my lecture, I will explain the various means available in international law to help secure compliance. And I will discuss the following 7 means, 1 to 7. The domestic implementation and application of international law, the enforcement actions of the UN Security Council, self-help, the law of state responsibility, international dispute settlement, compliance control, and the enforcement of international criminal law through domestic courts and international tribunals. So I start with the domestic implementation and application of international law. I consider this to be the most fundamental and important means of enforcing international law. The domestic implementation of international law refers to the enactment of rules by national legislators to fulfill the international obligation of the state. It is the first step needed to give effect to international law domestically. In the following examination, I will focus on the domestic application of international law. Now, Georges Sell expanded the theory of dédoublement fonctionnel. According to this theory, national organs play a double role. On the one hand, as organs of a state in its national legal order, and on the other hand, as organs of the international community. In contrast to executive and legislative organs of states, domestic courts are more likely to serve as true organs of the international community. Now, in respect of domestic application, it should be pointed out the primary function of a domestic court is to apply international law to the acts of its government, and where such acts are inconsistent with international law, to find them unlawful. Now, international law leaves to states to decide whether it has legal force in the domestic legal order. If international law has domestic legal force and is directly applicable, domestic courts can apply it and invalidate inconsistent executive acts. Furthermore, the rank held by international law in the domestic legal order is determined by each state. In some states, treaties prevail over statutes, while in other states, statutes enacted after treaty prevail over the treaty. Now, even when international law is not directly applicable, it can have various other effects in domestic law. In most states, it is an established principle. I'm talking about C, indirect application. In most states, it is an established principle that courts should interpret national laws in conformity with international law. This is referred to as the principle of consistent interpretation or the indirect application of international law. Human rights treaties can be applied to horizontal relations between private individuals. This is the third-party effect of fundamental rights. Now, the principle of a consistent interpretation or indirect application can be highly effective and can contribute significantly to the enforcement of international law domestically. While domestic courts may be reluctant to endorse the direct application of international law, they may be more willing to use international law indirectly for the consistent interpretation of national law. I move to external application. domestic courts can also enforce international law externally against foreign states. And I have referred to this means of enforcement as the external application of international law. The external application can take different forms. First, victims of violations of international law can sue a foreign state or its nationals in domestic courts for compensation. Domestic courts may find that violations have occurred and award compensation. Litigation of this kind flourished in the United States in the 1980s and 1990s. Second, on the basis of the universality principle, domestic court may prosecute and punish non-nationals who have committed certain international crimes abroad. Third, international law may also be applied externally in extradition or deporting a person to a state where there is a real risk that the person will be subjected to irreparable harm, such as torture. Fourth, a domestic court may refuse to apply foreign law and enforce foreign judgments on account of their inconsistency with international law. So now I move to section 2, enforcement action of the United Nations Security Council. The Security Council can take enforcement actions, which may have the effect of securing compliance with international law. Under the UN Charter, the Security Council can decide to take non-military and military actions, and its decisions are binding. They bind the UN members. Actions taken by the Security Council under Chapter 7 are administrative actions of an organ of the UN with a view to restoring peace. However, acts of states that threaten peace or breach the peace are often internationally wrongful acts. Thus, enforcement actions of the Security Council signify collective actions, collective sanctions against those illegal acts. Thus, enforcement actions of the Security Council may serve as a means of enforcing international law. Now, the ILC, International Law Commission, reserved the term sanction for a reactive measure applied by virtue of a decision taken by an international organization in accordance with its constituent instrument, in particular under Chapter 7 of the UN Charter. Indeed, the legal commentators have referred to actions taken by the Security Council under Chapter 7 as UN sanctions. Now I will move to non-military measures, subsection A. During the Cold War, Security Council rarely adopted binding decisions to take non-military measures. However, since 1989, the Security Council has adopted numerous decisions to take non-military measures. The Council often takes non-military measures in the form of economic sanctions, such as prohibitions of export and import, arms embargo, financial sanctions, prohibition of investment, and freezing of assets. Non-military measures also include prohibitions of travel, restrictions of cultural exchange, banning the entry of airplanes, and interruption of diplomatic relations. Now, comprehensive economic sanctions have a significant negative impact on the lives of innocent ordinary citizens in the targeted state. Therefore, since the 1990s, the Security Council has started to target specific individuals and entities. These sanctions are referred to as smart sanctions or targeted sanctions. The Council often establishes a sanction committee to monitor the implementation of sanctions. Now, non-military measures have not only multiplied, but also diversified. In 1993 and 1994, the Security Council created the International Criminal Tribunal of former Yugoslavia, International Criminal Tribunal for Rwanda, through its resolutions. The Security Council has taken a variety of other non-military measures, including the establishment of an International Commission of Inquiry, the referral of cases to the ICC, and the demand that the chemical and biological weapons be destroyed. Now I turn to section B, military measures. As the special agreements envisaged under the UN Charter have not been concluded, the Security Council is unable to take military measures with binding decisions. Before 1989, there was only one instance in which the Council only recommended military measures, which was in response to the Korean War in 1950. Since 1990, the Security Council has begun the practice of authorizing military actions by member states. An authorization of this nature was first given in relation to the Gulf War in 1990. The Council authorized member states cooperating with Kuwait to use all necessary means to restore international peace and security. And it was understood that all necessary means included military actions carried out by member states. Since then, the Security Council has authorized military actions on many occasions. In the Gulf War, this authorization had the purpose of halting Iraq's unlawful use of force. However, the purpose of authorizing military actions has become more diverse, including humanitarian assistance, peace building, prevention of genocide, and so forth. I move to subsections peacekeeping operations. Peacekeeping operations were invented partly because the Security Council was not in a position to take military measures. More than peacekeeping operations do not have the function of resolving the relevant dispute, let alone enforcing international law. Nonetheless, they are one of the most successful UN activities. I move on to 3, self-help. A state may resort to non-forcible measures without the authorization of the Security Council in order to induce another state to cease certain conduct. These measures are often referred to as sanctions. However, since they are unilateral actions taken by a state, some international lawyers avoid referring to them as sanctions. Now, the UN is not the only international organization that applies sanctions, because regional organizations do so as well. The Security Council has used or authorized a regional organization to implement the Security Council's enforcement actions. The measures taken by member states of a regional organization in accordance with such a resolution belong to the type of organized sanctions that I explained above, because they are taken in accordance with the resolution of the Security Council. African regional organizations have employed autonomous sanctions outside the UN framework on a member state of the organization. On the other hand, European Union has applied autonomous sanctions outside the UN framework on a non-member state of the EU. Restrict measures that member states of the EU take to implement the decision of the EU are in legal terms similar to unilateral actions taken by states without authorization of the Security Council. A state, I move to subsection A, retortion. A state may take a non-forcible measure in response to an internationally wrongful act of another state, while the targeted state may regard the measure as unfriendly conduct, the measure may not be inconsistent with any international obligations of the acting state. Where this is the case, measure is classified as retortion. And examples of retortion include the prohibition or restriction of diplomatic relations or other contacts, and the withdrawal of voluntary aid program. If an unilateral action of a state qualifies as retortion, it does not raise issues under international law. I now turn to section B, countermeasures. A state may resort to a non-forceful measure which is contrary to its international obligations. However, if the measure qualifies as a countermeasure, it is justified under international law. And international law is different from municipal law in that this kind of self-help is permitted and is often used by states. Countermeasure is a measure taken in response to another state's internationally wrongful act in order to procure its cessation. Under the UN Charter, armed reprisals are prohibited, and the countermeasure is an important means of enforcing international law. Countermeasure without resorting to armed actions. Now, a non-forceful measure must meet certain conditions to qualify as countermeasures. First, a countermeasure is only justified in response to a prior internationally wrongful act of another state. Second, a countermeasure must be commensurate with the injury suffered. Third, the state must follow certain procedural requirements. For example, the state must call upon the responsible state to fulfill its obligations and notify the responsible state of its decision to take countermeasures and offer negotiation. Fourth, countermeasures must not affect certain obligations, including obligations for the protection of fundamental human rights and discordance. The issue which is currently being debated is whether third-party countermeasures are allowed under international law. That is, whether states not injured by an internationally wrongful act of another state can resort to countermeasures. In 2000, the International Law Commission provisionally took the view that states other than the injured state were entitled to take countermeasures in response to a breach of an obligation erga omnes or an obligation erga omnes partes. However, the ILC eventually amended the articles on state responsibility. The final articles merely contains a saving clause in this regard. In the past, it was uncommon for third states to resort to countermeasures. However, since the 1970s, it has become more common for third states to take countermeasures
in reaction to certain serious acts of other states, such as the unlawful use of force and flagrant violation of human rights. Now, I now turn to Section 4, Law of State Responsibility. That's the next means of enforcement available under international law. The law of state responsibility has a function of not only providing remedies for violation of the rights of injured states, but also restoring legality through requiring the cessation of wrongful acts. Thus, the law of state responsibility serves as a means of enforcing international law. The International Law Commission adopted the Articles on State Responsibility in 2001. The articles are not legally binding as such, but many of the provisions are regarded as reflecting customary international law. The state responsible for the internationally wrongful act is under an obligation to cease that act if it is continuing. Reparation for injuries caused by an internationally wrongful act take the form of restitution, compensation, and satisfaction. And restitution means the re-establishment of the situation which existed before a wrongful act was committed. Thus, cessation and restitution have the effect of restoring legality. In this way, the law of state responsibility serves as a means of enforcing international law. When a state commits an internationally wrongful act, another state may invoke the responsibility of that state under the law of state responsibility. And if the dispute between these states is not settled by negotiations, they can have recourse to other means of dispute settlement. Thus, international dispute settlement plays a role in the enforcement of international law. So now I'm moving on to Section 5. Negotiations are the most fundamental means of dispute settlement in the international law. Nevertheless, it is also possible to involve third parties in the settlement of an international dispute. The various means of third-party dispute settlement available in international law are good offices, mediation, inquiry, conciliation, arbitration, and judicial settlement. In international law, as you know, adjudication is only possible with the consent of the states concerned. The means of dispute settlement that have been developed in international law may be classified into non-judicial and judicial means. Non-judicial means include negotiations, good offices, mediation, inquiry, and conciliation. Judicial means include arbitration and judicial settlement. International organizations are also engaged in the settlement of international disputes. However, the settlement of disputes by international organizations is not a distinct method of dispute settlement. Rather, international organizations utilize the various means of dispute settlement available under international law. Now, judicial and non-judicial means of dispute settlement are fundamentally different. Judicial means seek settlement of dispute by applying the law. In contrast, non-judicial means do not limit the applicable standard to the law. In addition, in judicial means, decisions of the third party are binding on the disputing party. In contrast, in non-judicial means, intervention of the third party, such as reports, views, do not bind the parties. Now, with respect to international dispute settlement, wide credence is given to the so-called linear track model. And this model assumes that the various means of international dispute settlement form a linear track with a list starting with negotiations and is followed by good offices, mediation, inquiry, conciliation, arbitration, and judicial settlement, linear track. And according to this model, the means which are mentioned later in the list are more desirable. And since judicial settlement appears at the end of the list, it is the best method to settle disputes of all kinds. Nevertheless, this model is inappropriate in the settlement of international disputes. For the effective settlement of international disputes, a multi-track model is pertinent and is called for. With respect to legal disputes, in which the states are seeking a solution by way of the proper application of the law, international adjudication is likely the most appropriate means. However, international law often lags behind societal developments because the international society lacks a formal legislative body. Such gaps may cause a dispute, for example, where one of the parties is not satisfied with the current state of law and demands that it be changed. International adjudication may not be the best method to settle such disputes. A more effective method of settling such a dispute is where a third party proposes a fair and equitable solution from the perspectives of justice and equity by means such as mediation. Thus, non-judicial means of dispute settlement plays a more prominent role in international law than in municipal law. I turn next to a means of enforcement called compliance control. This is number 6. It is also, this compliance control is also referred to as international control or international supervision. It refers to mechanisms whereby international monitoring bodies supervise the implementation of international obligations by states and urge the states to comply with them. These mechanisms have evolved considerably in international law and play a significant role in enforcing international law. Compliance control developed for the enforcement of objective obligations. For such obligations, compliance cannot be obtained through international dispute settlement, which needs to be initiated by an injured state. Mechanisms of compliance control were devised first in the area of international labor law. They have since then extended to other areas, such as human rights, the environment, the economy, peaceful uses of atomic energy, and arms control. Compliance control can be divided into judicial and non-judicial control. Regional human rights courts, the WTO adjudicatory bodies, and investment arbitral tribunals perform judicial control. Their decisions are binding. In contrast, in non-judicial control, the outcomes are given in non-binding forms, such as reports and recommendations. And compliance control can take several forms. So I will now examine each in turn from A to F. So the first form of compliance control is reporting. States may be required by a treaty to submit reports to explain the implementation of a treaty in their respective territories. The core UN human rights treaties have adopted a reporting system modeled on that of the ILO. And reporting systems have also been adopted by such treaties as those relating to the environment, the economy, and arms control. And monitoring bodies consider reports and make recommendations. Second form of compliance control is complaints. And this may be divided into complaints submitted by states and complaints submitted by individuals. And monitoring bodies consider complaints and make findings as to whether the respondent state violated its obligations under the treaty. In interstate complaints, a state party of a treaty submit a complaint against another state party, alleging that the latter is not fulfilling its obligations under the treaty. Thus, as a matter of form, interstate complaint has the appearance of a bilateral dispute settlement. However, as a matter of substance, it has a character of compliance control. Interstate complaints may be divided into judicial and non-judicial procedures. In judicial procedures, a state files a case with the international court against another state. The European Convention on Human Rights provides for such procedures. WTO dispute settlement procedures may be classified also as a judicial control. Contentious proceedings before the ICJ also have an element of judicial control when a state other than the injured state brings a case alleging violations by another state of obligations erga omnes or erga omnes partes. In contrast, interstate communication procedures under the UN human rights treaties may be classified as non-judicial procedures. For example, under the Racial Discrimination Convention, only non-binding recommendations can be made by the Third Committee and the Ad hoc Conciliation Commission. It is rare for states to submit an interstate complaint, except under the WTO agreement and the European Convention on Human Rights. Now, with regard to complaints submitted by individuals, they also may be divided into judicial and non-judicial procedures. Examples of judicial procedures include individual applications to the European Court of Human Rights. The judgments are binding. And investor state arbitration. Awards are binding. In contrast, individual communication procedures under the UN human rights treaties are a type of non-judicial procedures because views issued by the relevant committees are not legally binding. And if a committee finds a violation of a treaty, it not only indicates specific measures for the individuals, but also often recommends a revision of the law. We have witnessed a dramatic increase in cases brought before regional courts, regional human rights courts, and investment arbitral tribunals, as well as complaints submitted to non-judicial procedures, especially UN human rights treaty bodies. Now I move to subsection C. The third form of compliance control is fact-finding. This is a procedure by which a monitoring body finds facts and submit the report. And it is often used in the area of human rights. In accordance with the first additional protocol to the Geneva Conventions, a state party may allege a grave breach by another state of the Geneva Conventions or the protocol before the International Humanitarian Fact-Finding Commission established under the protocol. This procedure may be regarded as an institutionalized form of an inquiry, traditional form of dispute settlement. And this procedure has an element of dispute settlement because it may be initiated at the request of one state alleging a breach by another state, but it has a character of compliance control. Now, D, inspection. The fourth form of compliance control is inspection. It is a procedure by which persons entrusted with this task conduct an on-site visit to verify whether a state's act, facilities, or situations are in compliance with its obligations under a treaty. Mutual inspection by states is set out, for example, in the Antarctic Treaty and some disarmament agreements. The safeguards of the IAEA are a typical example and a good model of inspection administered by an international organization. The OPCW also conducts inspection. In addition to the normal inspection procedure, the Chemical Weapons Convention introduced the challenge inspection procedure. Under that procedure, a state party can request an on-site challenge inspection of any facility of another state party. While this procedure resembles the international dispute settlement because the inspection is requested by a state alleging another state's non-compliance, it has the character of compliance control. Now I move to E, non-compliance procedures. The fifth form of compliance control is non-compliance procedures, set out in many multilateral environmental agreements. The features of non-compliance procedures may be described as follows. A state party, the Secretariat, or an implementation committee may initiate a non-compliance procedure when there is a doubt about a certain state's compliance with the agreement. And after considering the information and observations submitted by state concerned and the Secretariat, implementation committee reports to the meeting of the parties, including recommendations, and the meeting of the parties they may take appropriate measures. Now, non-compliance with obligations under international environmental law is often caused by a state's lack of financial, administrative, or technical capacities. Therefore, the term non-compliance is used instead of violations. The procedure addresses not only violations of a state's obligations under an agreement, but also acts which may not constitute violations of the agreement. And measures taken in response to non-compliance are mostly facilitative and not punitive. Enforcement measures are rarely taken. Unlike an adversarial dispute settlement procedure, it is non-confrontational, mutually supportive mechanism. The unique feature of this procedure is that even a non-complying state itself can initiate it. While the procedure may be triggered by other states, it is rarely required for the complainant state to have been affected by the non-compliance of another state. Thus, it is particularly suited for controlling compliance with obligations erga omnes partes contained in multilateral environmental agreements. Now I move to F. This is not the form of compliance control. I'm talking about the distinction between compliance control and dispute settlement. When compliance control takes the form of an interstate procedure, it resembles dispute settlement. However, compliance control must be distinguished from dispute settlement. First, their purposes are different. While compliance control has the purpose of ensuring compliance with objective obligations, which are based on the common interest of the community, dispute settlement aims at settling a dispute bilaterally. Secondly, compliance control is not necessarily initiated by injured state. It may be initiated by a third state, individuals, or monitoring body. In the case of non-compliance procedures, it may even be commenced by the non-complying state itself. On the other hand, dispute settlement is usually commenced by an injured state invoking the international responsibility of another state, which has committed an internationally wrongful act. Thirdly, compliance control aims at preventing violations of international obligations, while dispute settlement is predicated on the existence of a dispute and is initiated after violations have taken place. Now, I now turn to the last means of enforcement of international law, which is the enforcement of international criminal law by domestic courts and international tribunals. Punishment of transnational and international crimes contribute to the enforcement of international criminal law. It has a deterrent effect and helps prevent such crimes from being committed. Now, first, domestic courts. Crimes are in principle to be punished by domestic courts. For transnational crimes such as terrorism and slavery, international treaties require the state parties to establish their jurisdiction over the crime, and these treaties also provide for the obligation to extradite or punish. And universal jurisdiction applies to war crimes, crimes of genocide, and crimes against humanity. Any state can try an offender of these crimes, no matter where the crime was committed. Some states have exercised universal jurisdiction over these crimes. Now, international criminal courts and tribunals. It was truly epoch-making that the ICC was established in 2003. The ICC has already dealt with a considerable number of cases. In addition to the ICC, a number of international criminal tribunals have been established. After the Second World War, international criminal tribunals were set up in Nuremberg and Tokyo. In the 1990s, the Security Council established the ICTY and ICTR. From the 2000 and onwards, a number of mixed or hybrid criminal tribunals have been established. The special courts for Sierra Leone and the extraordinary chambers in the courts of Cambodia have many similarities with international criminal tribunals. Now I conclude with concluding remarks. I have demonstrated that international law possesses various means of enforcement to help secure compliance. The ICJ has an important role to play in the enforcement of international law. However, international adjudication is but one means of enforcement, and it is not necessarily the best way of settling an international dispute. To strengthen compliance with international law, it is necessary to improve each of the means of enforcement and to utilize them appropriately to ensure that states act in conformity with international obligations. Thank you very much for your attention.
Okay, thank you very much, Judge Yuji Iwasawa. I would like to announce the presence of Adjoint Consul General of Japan, Ms. Komuro, and the Consul of Political Affairs and Press of Consulate General of Germany, Mr. Simon Frecker, and Mr. Eguchi, Director General of JICA, Japan International Cooperation Agency in the Brazilian office. And thank you very much for the audience. And Judge Iwasawa says that he can accept some questions from the audience. If our colleagues have some question, can make the question directly in English to the judge, or if you prefer, you can ask in Portuguese, and then I can translate it to him. So the floor is open. Pois não.
I see that some people believe that sanctions are defining characteristic of law. Do you agree with that interpretation? Does law require sanctions to be considered law?
Yes, I explained that most lawyers accept that sanctions are the distinguished feature of law and argue that international law is law because sanctions are available. And I explained the various means of enforcement, and these various means are different forms of sanctions available in international law. And I do not take the view that sanctions must be understood in the narrow sense of municipal law, like punishment for criminal law and enforcement of judgment of the court in civil law cases. So I explained the various means of enforcement available in international law as forms of sanctions available in international law. So I agree with, I mean, this is the view taken by most lawyers. And most lawyers take the view that sanctions are the distinguished features, but they understand sanctions, I mean, international lawyers, we understand sanctions broadly to cover these various means of enforcement. So I do belong to those group of scholars who take the view that the sanctions are the distinguishing feature of law, but sanctions are available in international in different forms from municipal law. Thank you.
Thank you. Any other question? Please.
Firstly, good evening, Your Honor. I would like to thank you for your outstanding lecture. My question would be about the legal standing of the International Court of Justice, because recently the ICJ has done a major shift on its interpretation about the erga omnes partes in the recent case of Gambia versus Myanmar that is still to be judged in its second phase. I would like to ask you, how do you assess the possibility of using the erga omnes partes to order conventions, especially related to some jus cogens obligations, for example, the apartheid and racial discrimination? Thank you.
I have limitations of making comments on cases, and also I can only answer this question within the constraint that I have. It is true that the court used the word erga omnes partes in Belgium versus Senegal and Gambia versus Myanmar. But I cannot go further than that, and I cannot make predictions, or I cannot make assessment on the future cases. But the point you made that the court referred to the concept of obligation erga omnes partes in Belgium versus Senegal, and also in the Gambia versus Myanmar is true. And I think the point you made is good, but I cannot comment whether it's a major shift or whether we have more cases. This is something you discuss, not me.
Yes, you should understand, Mr. Yosawa cannot make a very deep comment about this kind of stuff. So anybody else to ask a question to Judge? Oh, please.
Thank you. Good evening to all. It's an honor to be here and listen to your explanation. I'm a student, a master's student, and Professor Masato students at the Human Rights Asian Perspective. And regarding the about the specifically the last topic, it made me think about my study, my research, which is about the criminalization of ecocide, the proposal that ecocide would become a crime, and that much of the discourse around this idea comes from the point of view that by criminalizing ecocide, then we would resolve the problem of environmental impunity. I don't know if you have any opinions on that, and if you think that specifically the international environmental impunity would be solved with the amendment of the Rome Statute regarding the creation of a crime of ecocide, or if that topic could well be solved through the many other ways of enforcement available. Thank you.
I'm afraid that it goes a bit beyond the topic of my lecture, and also not necessarily related to international law. So I leave it you among yourselves to discuss this point further.
Thank you.
Oh, anybody else? Oh, please.
Like also thank you for the lecture, and my question regards the issue of the proliferation of international courts and tribunals. You mentioned some of them as the International Criminal Court, the ICJ, the Regional Human Rights Court, and during the first 2 decades of this century, these courts and tribunals were studied according to the perspective of the fragmentation of international law. And currently, the fragmentation is understood as legally administrable. It's possible now to deal with fragmentation, and it has been kind of normalized. And a new perspective that arises regards the possibility of procedural cross-fertilization between international courts, and there are some considerations, some current conditions that can allow it. For example, the discretion of adjudicators on procedural issues, and the duty of adjudicators to decide numerous procedural issues. And so my question is procedural cross-fertilization feasible currently? Can the ICJ learn from other courts and tribunals in what regards procedural issues?
Okay, thank you very much. It is true that we have more and more courts, especially in the last few decades. People call it the proliferation of international courts and tribunals. It is true that there are a number of international courts and tribunals now. And it is true that the commentators discuss so-called fragmentation and the possibility of international law becoming fragmented. But personally, I was a scholar before I became a judge, and I thought about this issue also. And my view is that this does not necessarily lead to fragmentation, because each court is working in their own specialized area, and they are trying to interpret international law. And even if sometimes their judgment are not necessarily consistent with each other, I do not perceive this as a fragmentation in international law. The different courts are doing their best to interpret international law in good faith and apply it to the case before the court. And by doing this, and each court and tribunal doing this, I think international law is getting clarified and become enriched. So I do not perceive this proliferation as necessarily leading to fragmentation. Now, as a matter of fact, different courts refer to jurisprudence of other courts. And this is maybe described as you said, cross-fertilization. And International Court of Justice itself referred to, for example, the jurisprudence of criminal tribunals in cases on genocide, or recently the ICJ referred to jurisprudence of UN human rights treaty bodies. And also in reverse, for example, International Tribunal of the Law of the Sea, ITLOS, has adopted, for example, the concept of plausibility in provisional measures, which ICJ started, but ITLOS also adopted it. And the ICJ explained a three-stage method of maritime delimitation, continental shelf delimitation methodology, and ITLOS adopted this methodology. So, I mean, there are cross-fertilization in both ways. So I'm not really concerned about proliferation or fragmentation. Thank you.
Well, Mr. Iwasawa, thank you very much for this brilliant lecture and for answering several questions made by our audience. I would like to thank you again to Mr. Eguchi of JICA, Ms. Komuro from Japanese Consulate General, Mr. Franke from German Consulate. And I would like to offer Mr. Iwasawa acknowledgement from our faculty. I will read this. The Department of International Law and Comparative Law of the Faculty of Law of the University of São Paulo, the Fujita-Ninomiya Chair of Japanese Development Studies, and JICA, Japan International Cooperation Agency, grateful, acknowledge Judge Yuji Iwasawa of International Court of Justice for the invaluable support given in promotion the activity of Fujita-Ninomiya Chair, and especially for delivering a brilliant lecture entitled Enforcement of International Law of the Faculty of Law of University of São Paulo on October 18th, 2023. Celso Campilongo, Dean of Faculty of Law, Gustavo Monaco, Head of Department, and Masato Ninomiya, Chairman. Thank you, Mr. Gucci, Mr. Omuro, please, Mr. Frank, Buzo. German consul, please. Okay, thank you very much indeed. Thank you.
ありがとうございました。ありがとうございます。
小室さんもどうぞ。
ちょっと後でね。
そうですね。Thank you.